The Supreme Court did not issue a ruling. There was no opinion released, no explanation given, no vote breakdown, no guidance for lower courts. And yet, what the court chose not to do may end up shaping the legal landscape just as much as a major decision. Most people only pay attention to the Supreme Court when something dramatic happens. A landmark case, a sweeping ruling, a decision that makes headlines and sparks debate. But the court does not exercise its power only through bold statements and published opinions. It also exercises power through restraint, through delay, through silence. And right now, silence is doing a lot of work. When the Supreme Court declines to act, the public often assumes that nothing has changed, that the legal system is frozen in place, that the status quo simply continues. But the truth is more complicated. In the judicial system, silence from the Supreme Court is not neutral. It doesn't pause the system. It allows it to keep moving, often in fragmented, uneven ways. Lower court decisions remain in effect. Enforcement continues. Challenges stall, and uncertainty becomes the rule rather than the exception. To understand why this matters, it's important to understand how the Supreme Court fits into the broader legal system. The court sits at the top of a hierarchy. Below it are federal appellate courts, often called circuit courts. Below them are district courts. When the Supreme Court speaks clearly, the rest of the system adjusts. Lower courts follow the guidance. Standards become uniform. Conflicts are resolved. But when the Supreme Court stays silent, lower courts are left to interpret existing precedent on their own. That interpretation is not always consistent. Some judges read Supreme Court precedent narrowly. Others read it broadly. Some apply it reluctantly. Others try to limit its reach. And when the Supreme Court declines to step in, all of those interpretations are allowed to coexist. This is how legal fragmentation begins. Different rules in different parts of the country. Different standards applied to the same constitutional question. Different outcomes for people depending solely on where they live. Over time, these differences harden. Judges cite earlier decisions. New rulings rely on old ones. What started as uncertainty slowly becomes accepted practice, even if the Supreme Court never intended that result. One of the most misunderstood aspects of Supreme Court procedure is the meaning of inaction. When the court declines to hear a case, it is not saying the lower court was right. It is not endorsing the reasoning. It is not settling the issue. It is simply choosing not to intervene at that moment. But that nuance is lost on most people affected by the law, because in practical terms, the lower court ruling continues to govern. The law is enforced, the penalties apply. The restrictions remain in place, and for someone living under those rules, the distinction between silence and approval doesn't matter. The effect is the same. This is why Supreme Court silence can sometimes feel like a decision in itself. It allows existing power structures to remain intact. It favors whoever is currently enforcing the law, and it places the burden of delay on those challenging it. That imbalance is built into the system. Litigation takes time. Appeals take time. Supreme Court review takes even more time. And when the court chooses not to accelerate that process, the cost of waiting falls unevenly. Governments can continue enforcing laws. Agencies can continue issuing penalties. Lower courts can continue ruling cases. Individuals and organizations challenging those actions must wait. That waiting is not harmless. It shapes behavior. People comply with laws they might otherwise challenge. Businesses adjust policies to avoid risk. Individuals make decisions based on uncertainty rather than clarity. This is how silence produces real-world consequences without ever appearing dramatic. Another reason Supreme Court silence matters is timing. The court operates on its own schedule. It is not required to respond immediately to emerging conflicts. It can wait months or even years before addressing an issue. Sometimes that delay is intentional. The court may want to see how lower courts handle a question. It may want a clearer factual record. It may want to avoid deciding an issue too early. But while the court waits, the system does not. Lower courts continue deciding cases. States continue enforcing laws. Agencies continue acting. And the longer that continues, the harder it becomes to reverse. Legal norms begin to form, expectations solidify, practices become entrenched. Even if the Supreme Court eventually intervenes, undoing years of enforcement can be difficult. This is one reason why some of the most significant shifts in the law happen gradually, not through single rulings. Silence allows momentum to build. It allows one side of a legal conflict to operate with confidence while the other waits for relief that may not come soon. Another critical factor is how lower courts interpret silence. Judges are not robots, and they read signals, and they infer intent. When the Supreme Court repeatedly declines to intervene on a particular issue, some judges interpret that as permission to continue down a certain path. Not approval, but tolerance. And tolerance over time can look a lot like acceptance. This is especially true when cases involve politically sensitive or socially divisive issues. The Supreme Court is aware of its role in the broader political environment. It understands that its decisions can provoke backlash. It knows that timing matters. In some cases, silence can be a way to avoid inflaming tensions. But again, that restraint has consequences. Avoiding controversy does not prevent the law from operating. It simply allows it to operate without clear guidance. That ambiguity benefits those with power and resources. It disadvantages those without them. This dynamic is not accidental. The legal system is designed to be cautious. It values stability. It resists rapid change. Silence from the Supreme Court reinforces that caution. But stability for whom? For those challenging the system, delay can feel like denial. For those enforcing the system, delay can feel like victory. Another misconception is that Supreme Court silence means an issue is unimportant. In reality, many of the court's most consequential decisions involve choosing when not to act. By declining to intervene, the court shapes the pace of legal change. It decides which questions are urgent and which can wait. That prioritization sends signals to lower courts, governments, and litigants. It tells them where to focus energy, where to push boundaries, where to exercise restraint. Silence is not the absence of communication. It is a form of communication. And right now, the message is restraint, delay, and continuation of the status quo. That status quo may be temporary. The court may eventually take up one of these issues, and it may clarify the law, it may reverse course, but until that happens, silence governs. This is why understanding Supreme Court inaction is so important. It explains why laws remain in effect even after major rulings, why enforcement continues despite unresolved questions, why different parts of the country operate under different standards. Silence fills the gaps between decisions. And those gaps are where most people live. The court's docket is limited. It hears only a small percentage of the cases presented to it. That means most legal disputes are resolved without Supreme Court involvement. Silence is the norm, not the exception. But when silence occurs in high-stakes constitutional disputes, its impact is magnified because constitutional rights are not abstract. They affect daily life. They affect freedom of action. They affect legal risk. And when the Supreme Court stays silent on how those rights should be applied, uncertainty becomes the default. That uncertainty changes behavior even without formal rulings. People become cautious, institutions become aggressive, lower courts become more confident in their own interpretations. Over time, silence reshapes the legal environment, not through force, not through decree, but through omission. For now, the Supreme Court has chosen not to speak. That choice allows existing rulings to stand. It allows enforcement to continue. It allows disputes to simmer rather than resolve. This does not mean the court has decided the issue. It does not mean the justices agree with what is happening below. It means the court is not ready to act. And until it does, silence will continue to do what silence often does in the law. It will favor the status quo. It will empower lower courts. It will shift the burden onto those seeking change, understanding that reality is essential, because the most important Supreme Court moves are not always announced. Sometimes the most important thing the court does is nothing at all.